Good day, ladies and gentlemen, and good day to my esteemed students of Law of Contracts. In continuation with our law series on the Law of Contract, Law 202, in this spring semester, we shall be looking at the sale of goods as a species of the Law of Contract. Recall that we did mention that the Law of Contract, as we did in Law 201 in the last fall, we looked at some the basis of Law of Contract. This time we are looking at some species of the Law of Contract. We had earlier on looked at agency, and today we are going to look at sale of goods, which is a species also of the Law of Contract. Now, we first look at the definition of sale of goods, which we define as referring to the transfer of ownership of tangible, movable property, that's goods, from a seller to a buyer in exchange for consideration, that is price, as we call it in our Law of Contract series. I will again define the sale of goods. We define the sale of goods as sale of goods refers to the transfer of ownership of tangible, movable property, that's goods, from a seller to a buyer in exchange for consideration, which is called price. Now, having looked at the definition of the sale of goods, now this definition is contained in our various statutory laws and then judicial authorities, as we are going to see as the lecture progresses. Now, the importance of the sale of goods is that the sale of goods transactions are pervasive in commercial activities and form the backbone of economic transactions. Definitely, sale of goods in any form at any time takes place between people in the markets, at the shops, and so on. So it is the backbone of commercial activities. That was why in my assignments to you, I wanted you to tell me the backbone, the relevance of contract to economic activity. Here, you cannot run away from the relevance or importance of sale of goods to commercial activity, because, as I say here, is the backbone of what? Economic transactions. So it is definitely necessary and very, very important that we have a law that will govern the sale of goods, because it's the economic, it is the backbone of economic activities. So we must have strong laws to fortify this particular activity in the economic activity of the country. Now, let us look at the applicable laws in Nigeria. We have, as I've often been saying, statutory authorities and judicial authorities in support of sales of goods. We have the Sales of Goods Act. We have the Contracts Act, as we've mentioned, and then we have also the relevant provisions of the Nigerian Civil Code and the Sharia law applicable in certain regions. When we look at the Sharia law as a species of Law of Contract later in this series, you will appreciate why Sharia law is also a statutory authority in the definition of sale of goods. Now, what of judicial authorities? We have plethora of cases that support the definition or the importance or the application of the sale of goods law in Nigeria. Nigerian cases law so many of them where the Nigerian courts interpreted and applied principles of the Sale of Goods Act to buttress the relevance and importance of sale of goods in the economic development of Nigeria, or in the as a species of what? Law of contract. Now, let's look at the formation of the contract of sale of goods. We have offer and acceptance. The offer is an expression of willingness to sell goods on certain terms. Then the acceptance is the unconditional assent to the terms of the offer. And then, of course, I must also recall that most of these offer and acceptance, the rules as we've seen them in our foundation lectures on law of contract, also applies here. For instance, when we say unconditional assent to the terms of the offer, so any conditional assent will mean that it amounts to counter offer, which goes to no offer at all. So let us look at also consideration. Consideration is here refers to the price, the agreed upon consideration for the transfer of the goods. We also have the intention to transfer ownership. Both parties must intend for ownership of the goods to pass from the seller to the buyer. There must be that intention. If there is no intention, it means it's fraudulent. The buyer must have the intention of receiving, whereas the seller must have the intention of parting with the goods by way of giving the goods to the buyer. Now, there are also conditions and warranties, just like in other contracts, as we have looked at other contracts in our foundation lectures. Now we have conditions. Conditions are fundamental terms of the contract that go to the root of the agreement. We have breach of a condition which entitles the innocent party to what? To repudiate the contract and claim damages. Apart from conditions, we also have warranties. Secondary terms of these are secondary terms of the contracts that are not fundamental. Breach of a warranty entails the innocent party to claim damages but not to repudiate the contract, just as we have it in our law of foundational lectures on the law of contract. Now, let us look at the transfer of property and risk. Now, property, what is property? Now, unless otherwise agreed, property in the goods passes from the seller to the buyer at the time the parties intend it to pass. Property, of course, means the possession itself. So, unless if they agree otherwise, the transfer of the goods passes from the seller to the buyer at the time the parties intend it to pass. What of risk? Unless otherwise agreed, the risk of loss or damage to the goods passes from the seller to the buyer at the time of the contract. Of course, again, they can agree that risk passes to me on delivery when I accept the goods, or risk passes to me immediately I pay the price, or what we call consideration in respect to the goods. So it depends on what the parties agreed upon. As we've always been saying, contractual agreements is left to the parties to agree upon any terms. The courts will not in any way draw the terms of the contract for the parties. The parties are free to draw the terms of their contracts. Now we have sellers' implied conditions and warranties. Of course, we first look at the title. the seller warrants that they have the right to sell the goods and that the goods are free from any charge or any encumbrance. That is, that the seller owns the property. It is his own and he has a right to sell it. So the title belongs to him. If you don't have a title to the property, you cannot sell the property. So there are these are some of the implied conditions and warranties on the part of the seller. That is, he has the title. Now, we also have description, that goods must correspond with any description given by the seller. The seller, in selling the goods to the buyer, has said, okay, that this is how the goods look like, and so on and so forth. He has described it. So that description must correspond with the one that will be given to the seller. You cannot describe a property that, oh, perhaps it is a car. You describe the car as being white in color, a Mercedes-Benz car, and so on. Then when you are delivering, you deliver a Peugeot, a black Peugeot. That is not in tandem with your implied condition as a seller. Now, there is also the quality and fitness for purpose. Goods must be of satisfactory quality and fit for their intended purpose. This is very clear, and the seller has an obligation that whatever he's selling must be of satisfactory quality and fit for the intended purposes. Now, what are the remedies for breach of contract? We have buyer's remedies, which are damages, specific performance, rejection or revocation of acceptance. Now, that's what the remedies open to a buyer. He can go in for damages, pray to the court to give him damages, or he can pray that the court should give him specific performance, or he could reject or revoke the acceptance which he had earlier on given. That is, if there is a breach of the contract. Now, what of the seller? Does he have any remedy? Yes, the seller also has a remedy. The remedy can be damages. It can be, again, right to rescind the contract. So both seller and buyer and the buyer have remedies in case of breach of contract. So in conclusion, we say sale of goods transaction involve the transfer of ownership of tangible, movable property in exchange for consideration. We've also looked at understanding the formation of the contract, conditions and warranties, transfer of property and risk, and then remedies for breach, which are essential for both buyers and sellers. We've also looked at the importance of the sale of goods, which we say is crucial for the Nigerian law students and practitioners involved in commercial transactions and trade to acquaint themselves with the sale of goods as because it is fundamental, it is the backbone to economic activities. Now, for your further studies, I will encourage students to explore recent case law and developments and statutory amendments related to the Sale of Goods Act in Nigeria. Thank you very much.